answer all your questions in a dynamic presentation. Let me ask this, by show of hands, how many of you think you're familiar with SARA? Excellent. And how many of you are hearing about this for the first time? One or two. So I'm going to ask those of you who think you know everything to bear with me, and we're going to kind of run through the components of SARA and give you a little update as to where we are. Now, the President's Forum began as a collaborative of accredited institutions. We have roughly about 200 institutions that work with us. We are based out of Excelsior College, which is a pure online independent college, not-for-profit in Albany, New York. It is the former Regents College of the state of New York. We focus on online, President's Forum, post-secondary education. We have participants from all sectors of post-secondary education, and our goal is to formulate policy that would advance the best practices in online education. The reason I do background a little bit on the President's Forum is I want to emphasize that we have been looking at barriers to the delivery of online education for the last 10 years. Our work initially in discussion of state authorization came out of a question that we asked a number of state regulators, which was basically, what do you actually need to know in order to authorize an institution? And we worked on this for 7 or 8 years. Then, all of a sudden, the federal government aligned all the planets for us and came down with program integrity rules. And of course, everybody was running around trying to figure out, what does authorization mean? What do you need to do with states? Now, I want to emphasize one point. The federal government merely put the spurs to the states to pay attention to authorization under Title IV. That has been disallowed in the courts. There's currently no federal mandate for state authorization. It's buried within Title IV, where the expectation always was that you would be in compliance with state law wherever you serve students and were delivering federal financial aid. We are talking about state law. Once you move away from what happened in Title IV, all of the states have authorization rules when an institution delivers services to their residents. Now, the problem that we addressed early on is that states and territories all regulate higher education within their borders with varying requirements. The cross-state online education, as you all know, has expanded dramatically. What was a sidecar to contemporary higher education, post-secondary education, is now the primary means of delivery at many campuses. At present, without SARA, there is no alternative to each institution registering or being acknowledged by individual states where you deliver services. Consequently, thousands of institutions, my own being a national institution, are required to have dialogue with 54 states and recognized territories. The process is inefficient, the process is costly, the process is a barrier to students receiving services. I'm going to show you an example as to why we got to where we got to today. This is my institution. If you can't hear me, I'll speak up.
Paul, can you speak up? Can't hear you. You can take the mic off, right?
How's that?
Perfect.
Sorry. This is Excelsior College as of July 31, last fiscal year. The application fees for states was costing us $112,000, almost $113,000 just to process applications. Agent license fees, there are many buried costs here that institutions and regulators and state officials don't often recognize for institutions. But we have to license agents in some states. We have to file business fees. We have to have surety bonds wherever we operate, agent bond fees, legal consultants, because not too many people know all the rules and regulations. obligations, and if you get into rules and regulations by reading statute, you will discover that they are a little bit vague. Therefore, it becomes a case-by-case negotiation, usually with the state agency, where policy is often made on the spot. Our additional staffing, myself included, came out to approximately $150,000 annually, but our current costs are up around $500,000. So we have estimated that it has cost us about $1.25 million to be in full compliance nationally. Now again, my institution operates and deals with students in all states and territories. But even on an individual basis, it can become highly costly. Your state of Massachusetts has enjoyed the reputation of being one of the high-cost states. I can speak to that in great detail. Initially, people wanted to know from us, where did SARA start? How did it start? Well, originally the President's Forum, which is my group at Excelsior College, really a policy institute, partnered with the Council of State Governments, my colleague who introduced us, and we developed a model state authorization reciprocity agreement, a compact, and this was funded by the Lumina Foundation. Over time, because ours was primarily a product of talking to regulators, and we realized that we also had to include institutions and lots of other organizations. At the same time, the WIGI, the Western State Higher Education Compact, took the work that we had done and developed what was called at that time WSARA, which had a very strong institutional focus. We brought in the other regional compacts, SREB, MEC, and NEMI, into that discussion. And at that point, we decided we would just call it SARA, and we would have one document. Then excuse me, SHIO, the Chief State School Officers, and APLO, which is land-grant colleges represented through that association, came together. SHIO's interest was in extending accreditation, strengthening it. APLO, public institutions at that particular point in time, really did not feel that they had to be regulated or would be regulated. They found out that that was not true under state authorization. Took all of the work that we put together, and former Secretary of Education Riley chaired a commission on the regulation of post-secondary distance education. And what we have now is SARA, the agreement that you have before you. And NC-SARA is the national commission that forms policy for SARA. I sit on that commission, as does CSG, and all of our work has been funded by both Lumina and the Gates Foundation. Point to be made here is this is probably the only time that all of the sectors have come together on an agreement, and also it is an agreement that has been extensively vetted by virtually every sector in post-secondary education. Now, the nationwide system for reciprocity that we're proposing will be administered by the 4 regional compacts that exist. And the reason for that is that they already maintain a relationship with states and state legislatures, as well as with the institutions within the states. And this was a ready-made system for administration. Now, this is not a formal compact with the states. Each state passes legislation. This is, in essence, a strong agreement between states and between these organizations. Now, a point. SARA establishes a voluntary state-level reciprocity process. This is voluntary for states. It is not a mandatory system. It is voluntary for the institutions that choose to participate in SARA. If your state ultimately enables SARA, individual institutions may choose to deal with it or not deal with it. However, there will be a competitive advantage to being in SARA, because in essence you will not be paying fees for authorization to every single state. If you choose not And those fees, by the way, are passed on in the form of tuition and fees to students. If your institution chooses not to participate in SARA, for whatever reason, it then will have to deal, as the current system, with each individual state where services are delivered to students. Our view is this is a more efficient system. It is certainly a uniform and effective system. It is less costly to institutions, and ultimately may be less costly to states where they want additional capacity, additional curriculum, without having to develop it or build it. Now, the one point to be made here also about it being more efficient, effective, and uniform, and I'll use my own state of New York. New York does not regulate pure online. It only regulates institutions that want to have physical presence. As such, for New York, this is a step up. New York is one of the most heavily regulated states in the nation. In essence, this provides consumer protection for students who would not normally have it. When those students are served by a New York institution, wherever that student is, that student now has a course of complaint and an expectation of service that has not existed for New York. So, rather than argue that for some states this is a reduction of quality, here you have a very highly regulated state where it is decidedly a step up in providing consumer protection that did not exist. Now, as I've said, it is voluntary for states and institutions. It acknowledges the traditional roles of higher education in the triad, meaning accreditation. Many of the components of SARA are built upon the accreditation process and federal expectations for the financial welfare of an institution. It provides a framework for state-level reciprocity that requires states to approve their in-state institutions. It is not just a matter that the state joins and then the institution can say, I want to do this. Each state, once it participates, must approve the institutions to participate. The state agrees to impose no additional non-SARA fees or requirements. In essence, and I want to be very careful how we state this, SARA does not permit a state for out-of-state institutions to impose fees for participation or fees for authorization. It does not intrude into the process where if an institution wants to come into your state and establish physical presence, then whatever you require is legit. Are we clear on that? This only applies to online, for the most part, distance, out-of-state institutions that are operating at a distance. It does not apply to institutions that want to come into your state, have a branch campus, open a facility, an office, establish presence. It also rationalizes the definitions of presence. Such things as having a computer server located in a state, or having faculty reside in a state who may not be teaching anybody in that state, are no longer in the list of activities for physical presence. Now, again, it requires states to approve their in-state institutions for SARA participation, and this is based upon accreditation and financial stability and the ability to resolve student complaints. Now, what SARA does, the heart of SARA, is that SARA now makes the home state responsible for the conduct of its institutions towards students, wherever those students are. Now, there has been some confusion of late about this, in that in my own home state, and I will tell you so we're clear, the regents of the state of New York have voted for participation in SARA and directed the Department of Education to pursue the activities necessary for their participation. The only question that was raised in New York, a heavily regulated state, is what has Massachusetts done, and are we first? But saying that, in essence, the home state now, New York, will be responsible if, for me, Excelsior College, if a student has a complaint, After that student has exhausted the complaint process with my institution, they then will have the ability to appeal to New York, and New York will have responsibility for coming to me and saying, get it right. Now, this does not add tremendous or additional burden. To date, this has made no changes in behavior, but remember, these are institutions that are chartered by the state. They're already responsible for me, my accreditation, my behavior. But heretofore, before this, if a student was in another state, we had to rely on an attorney general or somebody else to field student complaints, and students were not often dealt with fairly, and those complaints were not often processed. Now it says basically that to be a SARA participant, the home state and those institutions have to bear these responsibilities. This is a major step towards consumer protection, towards compliance. This is something that everybody should be in favor of. And it is only open to degree-granting institutions from all sectors. Sets forth a reasonable set of triggers for physical presence, preserves state approval of oversight of the ground, as we've said, and we've talked about the home state. Now, the benefits of SARA is that it provides a more efficient provision of distance education, reduces the number of applications to other states for institutions, reduces the number of the state regulations to monitor for changes, reduces cost, potentially lower fees and lower tuition for students, and provides institutions with a decided competitive advantage when they decide that they want to enter into online or distance learning. Now, what does your state have to do? It has to determine first if it wants to participate. It may need to make changes to statutes and rules. This is not uniform. There are states that are able to participate with no statutory change. There are states, because some of their rules or regulations have been placed in statutes, such as refund fees, for an example, in some states, that may have to make some adjustments. It needs to identify a portal or lead agency to be responsible to approve institutions and participate, have those institutions participate in resolving complaints. For us, it would be the State Department of Education as the lead agency. Needs to adopt an in-state funding model if needed. An example of this is New York is thinking of charging an administrative fee for participation for institutions to cover their costs of staff. That's possible. Develop and submit SARA plans to the state's regional compact for approval. You have to apply to your regional compact with a plan and have it approved. I'm sure Michael can talk more extensively to that. The benefit to your state, it expands educational offerings available to students worldwide, as it were. It allows SARA states to focus on their home state institutions exclusively and not worry about everybody else out there. It maintains state regulation of on the ground, as we've discussed. Other SARA states will help resolve any complaints because you're now in a membership agreement. It reduces costs to institutions and to students, and it has no cost to the state. The institutions pay the fee to participate in SARA. Enables more. The benefit to the institution is obvious: more efficient provision of distance education, reduces the number of regulations that we have to deal with, reduces the number of applications we have to deal with, and most importantly, reduces the overall cost of delivering education, something I think we all want. Now, the benefit to students, I think, is obvious. It's both better offerings, better resolution of complaints, consumer protection. I'm going to let others talk to the regional update, but for more information, so that you know this, President's Forum is currently being funded by the Gates Foundation. Our mission right now is to provide education and outreach about SARA. CSG works with us as a partner. NC SARA is the policy group with SHIO, and the regional compacts are responsible for implementation of SARA and each regional compact has a person designated to assist you. Yours would be within Nebby, Sandy, Darn, and I think that you can contact any of us or look at any of our websites for full information, and we're always available to you. Thank you very much. Any questions? Simple questions, hard questions that you want me to take? For some states is an increasing moneymaker. I think that the question becomes the institutional pressure not to pass the costs on to students. And that has been a strong driver in this, because in essence, regulation really is driving our costs. The other fact is that for a large number of these state agencies that are collecting massive fees in some cases, only a very small percentage of that fee applies to post-secondary education and their activities, and a lot of it is going into the general state fund. So the argument is a weak argument at best. We do not deny that individual state agencies are going to need some staffing to maintain it. I personally look at this as a shift in roles in terms of policing the external to policing the internal, which they already do. But in the cases I've said of New York, they're going to charge a modest administrative fee to pay the... New York is not affiliated yet with any regional compact, so as such, they've got a $50,000 cost to participate with a regional compact. And there is some staffing need in New York because, quite frankly, the governor slashed the budget repeatedly, and within the agency itself. Now, we've separated the argument, but for a modest amount of money, they want to charge a small fee. It's infinitely less than what we're paying to participate with the other states. Anyone else? Sam?
No, I was going to say thank you. So I'd like to have our panelists come forward. I know everyone's eager to hear from our department and our institutions. And Michael, would you mind giving a brief introduction of our panelists? And Paul, will you moderate the conference? Thank you.
All right, good afternoon, welcome. Thanks for joining us here. We realize that Nurses Hall can be a little bit of a sort of an auditory experience here, so thank you. Let us know if you can't hear anything. My name is Michael Thomas. I'm the president of the New England Board of Higher Education, one of the aforementioned regional higher education compacts. My role is to quickly introduce participants, and I just want to say thanks on behalf of Debbie, particularly to the Council of State Governments and to the President's Forum for inviting us to be part of this event and to benefit from their leadership. As mentioned, Debbie's role really is to be the implementer of SARA in the region. It's our job to help the individual states in New England, as well as New York and New Jersey, have the conversations that they need amongst the stakeholders, which I think are adequately represented here today. State approval and authorizing agencies, legislators, institutions, as well as students and student advocates. And so really, to the extent that we can continue to be part of the conversation here in Massachusetts, we desire to do so. As you may be aware, New Hampshire has joined SARA through NEVI. We also have Vermont that's similarly situated to begin participating, and there's legislation working its way through the process now in both Rhode Island and in Maine. And I think Paul gave you an update on New York, but we're also working closely with New Jersey, and we expect that there's a likelihood that legislation will happen in New Jersey in the coming weeks as well. I also wanted to say thanks to the NEVI staff, Sandy Dorn, and Kylie Dan, Jice Curtis, and Darren Fullweiler, and Carolyn Warwick, all of whom have helped. And thank also Representative Paul Broder and Representative Paul Mark, who's the vice chair, has been the vice chair of the Joint Higher Education Committee, for joining us here today. We appreciate their leadership. Let me now introduce, in addition to Paul, just a few words maybe quickly about Paul and then his co-panelists. Paul, as you know, in addition to being the president of the forum, being the head of the President's Forum, has worked as an administrator in a number of SUNY campuses, including SUNY's Rockland Community College, where he was the Vice President for Institutional Planning and Advancement, as well as an Assistant Vice President for Government Relations at SUNY's Empire State College, a person who's worked very closely, as you can tell, in the adult and the sort of ongoing learning field. We're pleased to have Dr. Megan Allen, who's here representing Mount Holyoke College. She is a program developer and instructor. She is a National Board Certified Teacher, was in 2010 the Florida Teacher of the Year. Florida sounds nice, doesn't it? Also working there with the Center for Teaching Equality. Currently, she's assisting them in, as I said, program development and does a lot of work related to K-12 professional development. We appreciate you being here. Stacy Charmonte, who is the Director of Operations for the Corporate and Professional Education Division at Worcester Polytechnic Institute. They are working to manage both logistics and operations for, I believe, 50 continuing professional education and online programs for graduate students and working professionals there, and we appreciate you being here. Many of you know Dr. John Cunningham, who's the CEO of UMass Online. John is in his third year of service as CEO of UMass, where they have 140 degree and certificate programs, 80,000 users, and had served previously as the Deputy Provost at UMass Amherst. And then lastly, Carlos Santiago, Senior Deputy Commissioner for Academic Affairs here at the Department of Higher Education of Massachusetts. Many of you know Carlos' distinguished career in higher education. He was previously the Chancellor for the University of Wisconsin at Milwaukee, and also served as the Chief Executive Officer of the Hispanic College Fund in Washington, D.C. So without further ado, let me just say thank you again for being here. Thanks to the panelists for their participation and to Paul for his presentation and facilitation. And if there's anything that Nevi and our staff can do for you as you continue this conversation, please let us know. Paul.
I think we'll start with our panelists and ask each to make a brief statement about their impressions of SARA and where they're going with it. Megan, why don't I start with you?
Good afternoon. I have to say I was a little disappointed because Paul, upon meeting him, said that he was going to be doing a puppet show to walk us through what's happening with SARA, so the educator and me got really excited. Next time. So we are in a time of increased accountability in public education with rapidly decreasing morale and retention and increasing attrition. And at Mount Holyoke, we spent a lot of time thinking about how we can better support public school teachers, listening to them, listening to districts, and creating programs that will better develop teacher leaders so they can lead reform in public education. We are at the very beginning of this journey when we're looking at distance learning. How can we make this accessible to teachers nationwide? We have two small programs that are in development. One is a Master's of Arts in Mathematics teaching. That one we're in the first year. It's built on a professional development program that's been nationally recognized for about 30 years. So trying to crystallize that into a master's degree. And then we have a Master's of Arts in Teacher Leadership. And this is done in partnership with the National Network of State Teachers of the Year. And we're hoping to launch that this upcoming summer. So these are tiny boutique programs. We're looking at cohorts of about 10 to 20 teachers. Classes are done online, but this is done with dynamic hybrid learning environments. So we're talking totally face-to-face using video conferences. So we'll have synchronous conversations and think about creating learning environments that replicate really great best practices in the face-to-face classroom. And we're using Zoom technology for this. So this is not like fly-on-the-wall video conferencing, but this is having teachers working on solving these really big issues in education together. We are facing some real challenges and barriers in developing these programs. We are currently authorized to do business in a small handful of states. We're looking at 4 right now, so small but mighty. And if we were authorized to do business in every state, it's really cost prohibitive. Again, we are are the mom and pop business in what we're doing. I have great respect for larger programs. My competition is University of Phoenix, Walden University, these really large and great programs. But we're kind of trying to create something that's a lot more individualized, a lot more face-to-face, something different for our teacher leaders. We are the small but delicious gourmet coffee shop across the street from Starbucks, or I guess up here would be Dunkin' Donuts. So we are that small business. And you're looking at the marketing department, the web development team, the communications department, the curriculum department, student advising, business, program developer. It's me and a couple others. So small but mighty. This is a startup. We don't have the manpower or the woman power really to look at applying for authorization in every state. We don't have the finances to apply in every state. And it's really challenging to grow small programs that can have large impact when our hands are tied by the students we can accept and the students that can have access to this kind of a program. We are a small business, we are a startup, we are trying to grow and reach our full potential. And we have an opportunity with SARA to fix that so that high quality distance learning is available to all teachers, not just those in certain states. Thank you.
I'm going to ask John Cunningham to take the podium and speak to UMass Alum.
Thank you very much. Good afternoon. As you noted, I'm representing UMass Online, and we're very keenly interested in this. And an alternative to what you've heard of SARA is we look at this as state agreed upon reasonable approaches, which we've never had and we would love to have. So it's reciprocity, as the analogy is often used of driver's licenses, but it's also bringing some reasonableness and some operative sanity to an area. UMass Online is active in 45 states. We offer our 140 degree certificate programs to something approaching 10,000 students in those 45 states. We would like to have it available to students in 50 states, but there are 5 that are lawyers who have spent a lot of time and a lot of effort to get us into the 45, have run into roadblocks and idiosyncrasies, we have to put on our website that if you live in one of these 5 states, you may not enroll in our programs, and we're sorry about that. So we do hope that we can find a way that is reasonable and operatively sane and efficient that will help our undergraduate campuses deliver the quality programs that have been approved by the Board of Higher Education. We only offer the same programs we would offer on our campuses to students who want them, and ours are asynchronous, 24/7, 365 courses to help working adults and others achieve their aspirations for college education while in the workforce and dealing with families and so on. So we're very eager to find a solution that helps us do these. I will say that of the 5 states that we found too difficult to interact with, 3 of them have joined and approved SARA already. So it just tells you, I think, that in some of these states they haven't looked at what they were doing and saying, and when they looked, they found out that they were part of a system that could be improved immensely. So I don't want to take a lot of time. I'll answer questions later as needed, but we hope that this does lead in a much better direction than we have today. Thank you.
For those of you that are curious, there are currently 19 states that have authorized SARA at this point. I believe that by the end of the year, certainly we'll be pushing close to 30. Stacey?
So I think Paul knew what he was doing when he put me in between Mount Holyoke and UMass, because WPI falls really in the middle, maybe a little bit more on the smaller side in terms of scale. We have roughly 11 fully online graduate programs currently, 621 students in 38 states. And for effect, I thought we'd share this is one of 3 of our state authorization binders to make sure we are in compliance. This is one state, by the way. We're lucky that the other 2 binders weren't quite as big as this one. WPI, for those who know us, and many of you in the room will, is one of the nation's oldest technological Several of the programs we offer online they're the same programs we offer on campus, very much like the online. They are niche programs that aren't available everywhere. There's one of 3, 4, 5 in the country that students can sign up for. In some cases, that makes us, one of the only options. So the intent of the state reciprocity agreement is really, the intent of the state legislation to protect students is really working against them in many cases. Where now students, like UMass Online, in 5 states can't sign up and take those programs. We're down to just 2 that we've had interest from that we are not authorized in. But we have to say no. If they want one of those programs, they really can't get them anywhere else because we can't come into compliance or aren't ready or aren't willing to come into compliance because of the level of work and effort and cost that would be involved. So unfortunately, I think it's backfiring a little bit in terms of the intent to protect students and actually, in some cases, presenting barriers that really don't want to protect students. And we all know that there's a significant issue with the ratio of administrators to faculty and to students in higher education. Right? It's a topic in every publication we read. And this type of involvement to come into compliance to offer online programs requires more and more resources. There's 2 of us from WPI today, and we're just a fraction of what it takes to get this done. So glad to be having these conversations that will greatly simplify things that we are able to adopt reciprocity agreements.
Before we move to questions, just a side comment, actually two comments. First is for Lumina and Gates, which funded a bunch of our work. This is about degree acquisition. This is about the national need for students and national need to move students toward degree completion for a productive economy and a productive workforce, and productive society. Online, distance education. These specific needs supersede just institutional benefit here. But please bear in mind that is one of the prime reasons that we did develop SARA. Carlos Santiago, department. I'm going to ask Carlos to finish up for us and to summarize.
Thank you so much. This is an important conversation. This is a conversation that will have a fundamental impact on the Commonwealth. The Department of Higher Education in 1944 was asked by this legislature to oversee a number of elements of higher education, 2 of which are very important to us. One is academic quality, and the other is consumer protection. We would be remiss if we did not take these issues seriously. In Massachusetts, there are 2 levels of oversight of our academic institutions, among the most renowned in the world. These oversight is partly accreditation, institutional accreditation by NEASC, and program approval by the Department of Higher Education. Both are separate, complementary levels. If you were an online provider and you came into the state of Massachusetts without physical presence, as many institutions do now, you're totally unregulated, as Paul had mentioned. You don't pay a fee, you come in, and you can be teaching literally thousands of Massachusetts residents for which the Department of Higher Education has no authority. That poses some significant problems. Now, if that same institution decided to have 1 clinical student on the ground in Massachusetts, the full oversight authority would fall on that institution. We agree with the proponents of SARA that this does not make a lot of sense. Last year, the Board of Higher Education conducted a report from a subcommittee of the board and came up with three perspectives, interrelated. The first was, we need to have a sense of the online providers that are coming into Massachusetts and serving our students. We get the complaints from the students, we have no authority, and that's fine. What we are introducing, or intend to introduce, is a registration system. Minimal fee, you come in, it's not program approval, it's not program review, it's not institutional accreditation, it's simply a registry. We want to know who is in the state of Massachusetts conducting business among our educational institutions. We know that accreditation institutions are not all the same. Yes, they can be federally approved, but some are better than others. We know that state authorization agencies are not all the same. Is it any surprise? The states within New England that provide the most oversight of their in-state academic institutions are Connecticut and Massachusetts. Two states that have been looking very closely at SARA and have some concerns. At the same time, we believe reciprocity is the solution. We think this agreement needs to be tweaked. In many respects, reciprocity can be gained not only in a regional compact, as SARA provides, but we can do it state to state. We've already begun conversations across state borders to come up with reciprocity agreements. We're very concerned about the provisions regarding academic quality. We're very concerned about provisions where we would have virtually no oversight of consumer protection complaints that would come to us from providers from other states. Is the legislature prepared to turn over the consumer protection that it has granted its citizens for many years? And remember that in 1944, when they created the agency, it was because there was a need. And that need was that the GIU was bringing to Massachusetts higher education a number of providers that were viewed as not playing by the rules. They changed the rules. Tuition went, instead of to the institution, it went to the individual. We've had other cases. The criminal justice program that was launched a number of years also created a situation where the legislature asked us to intervene. We think that is a legislative role. We're willing to abide by whatever changes the legislature clearly wants us to do. We think reciprocity is a positive signal. And we are prepared at this point. We're going to conduct surveys across our institutions to see what are the institutions that the states that John Cunningham needs help with. And those states, we can intervene and we can create individual reciprocity agreements. I've just put one word of caution. Higher education is in a very delicate, competitive, and fragile state. Institutions change hands on a weekly basis. Institutions rise and fall. Consumer complaints are significant across the board. I don't know if we have representatives from our Attorney General's office, but we work with them to resolve complaints. I would caution the legislature that in the last 30 years we've seen a number of bubbles and bursts. We've seen the dot-com bubble, we've seen the housing bubble, we've seen the banking bubble. There is a considerable worry about affordability and student debt. We must be very vigilant in terms of how we protect this industry in Massachusetts. It is our third largest. It is our third largest industry after biomedical sciences and after healthcare. We simply need to do this in a more informed way. If there are 19 states that are participating in SARA, let's see how that experience has been for them. We want to open the doors to all of the institutions that we have in the state, but there's a lot at risk, and we don't do this lightly, and I know the legislature won't as well. We'll be more than happy to share all the data we get. We have revamped our program approval processes. What used to take literally months, on average, since August of last year, our program approvals average from 6 business days to 13 business days. There are ways to improve our processes. We want to work with SARA. We think there's a way to have these conversations. We are all in favor of program quality, consumer protection, and overall the health of the higher education sector in Massachusetts. Thank you.
We're ready to take questions. Sir.
My name is Howard Gordon, I'm president of New England College of Business and Finance. We are a fully online college. I think we're the only fully online college in Massachusetts. So last year we had 2,000 students and they never stepped in the classroom. We're operating in about 40 other states, and so we're going through the same kind of licensing bureaucracies that my colleagues on the ground have talked about. But my question is this: does it make sense to go back to where the genesis of this problem is federal regulation? Because to me, I applaud the efforts of SARA. I think they're absolutely critical. But does it not make more sense just with railroads, the internet, pharmaceuticals, to to get back to the state commerce clause and just say, if you're going to be an online provider going across the country, that you don't need to get licenses from states. I think we have a Republican Congress, maybe they'll be a little bit more deregulatory. Could we not make it a condition, Title IV participation, that if you're an accredited college and you're involved in Title IV, that as part of institutional capacity, you provide some consumer protection, you provide a contact person for complaints. So I think this is a great effort, but I wonder whether we should go full circle back to the feds and try to get this resolved in either a statute or a regulation so that we have a level playing field. I understand what we're doing in Massachusetts. I don't think we can be protectionist. I think we have to be ready to compete. We want to go out to other states, let other states come in here, get rid of the regulation, use Title IV, use consumer protection, use accreditation, and get rid of state licensing and all.
Anybody who wants to answer that? I have an answer. I think you've seen how well the federal government has regulated program integrity rules. It is not a place I would want to go. The federal role has been with financial aid. I would not want to extend that role where it is not constitutionally dictated to governing the state's choices in this matter. It would make it overly complicated.
I'm not going to preempt. I'm just saying, if you are Title IV certified, accredited, you are deemed, and no physical presence, you are deemed to be qualified to offer programs in every state. I'm not talking about getting involved. I'm talking about preemption of state regulation.
I understand.
Very different. Very different.
I'd be happy to debate that with you kind of offline, but it is far more complex than that. Anyone else? Sir.
Dr. Santiago has posed two concerns that the Congress has. No, I think the address of the first concern was the actual agreement was that Commonwealth would have no idea who was in the marketplace here in Massachusetts, so the market would like online registry. The second one has to do with oversight, some level of oversight for consumer protection, consumer complaints, and the like. So those, and there were a couple of points being made. Those are the two main concerns that we've been hearing. I'm sorry, I've been dealing with the single person. So those are two main concerns that we've been hearing from our colleagues within the state universities and others from the department. So I'm wondering what your perspective is on those two points.
Could you repeat those questions?
Well, as I understand it, the first question has to deal with consumer protection and consumer complaints. For many of us, our belief is that in terms of consumer protection, this creates a level playing field. It now gives a rational system for dealing with student complaints. It is not true nationally that attorney generals have been highly cooperative within this venture to deal with student complaints, especially for institutions that are out of state. This, in essence, turns it around and says that where you have a home institution dealing with students, perhaps in another venue, as part of the agreement, you will be responsible for student complaints that come your way. It is not going to increase the load. You already charter and certify those institutions within your state, so it's not going to be a heavy lift. If anything, it would be my view that it provides a degree of consumer protection that doesn't currently exist, especially in a state like Massachusetts or New York that does not regulate purely online. So I think that this is a bone of contention that we're not going to agree about. State your second for me again.
The second was, what's the opposition from the opponents of SARA having an online registry?
There are states that have asked for notification that you are dealing within the state, Maryland being an example. I personally would have no objection to a state asking me whether or not I'm serving students within the state. SARA provides, remember, not all institutions are going to join SARA. it's a voluntary system, so if the state feels a need to know that other institutions are operating within the state, that's the state's prerogative. The issue becomes one of the imposition of additional regulation and fee, or possibility of fee, but that's one of the attractions to SARA, because institutions that function within SARA have a uniform set of expectations. There is an argument that was raised by Dr. Santiago, and this is the argument that we hear continuously about quality as such. I think it's something we're just going to have to disagree with. For some states, it will be a surrendering of over control, and for other states, it will be a leveling up. But I don't see this as an attack on quality. Quality is determined by the institution.
And also the home state.
That's correct. We're not changing the home state's regulations. I'm going to ask Dr. Santiago to comment on one thing he said about additional external providers, because I did not understand what you meant by that. You had said in the complaint process that the state will now have to deal with a number of external providers or additional providers. And so I thought that's what you had said.
The consumer protection?
Yes.
The concern that we have is that if there's a consumer complaint from a resident of Massachusetts who's taking an online course out of state, that particular institution, that online institution, is regulated by the home state. If we have particular standards with respect to consumer protection, say a refund policy, where we have a particular level, we expect institutions, our home institutions, to abide by a given refund policy or approach, we would have, my understanding of SARA is that we would have no way to address that particular complaint if we had a real disagreement with the state authorization. Let's say they're Arizona, and they have a different standard than we do. It was, my understanding is that Arizona would basically say, this is our policy, and it may not be the same as Massachusetts, and that's it. There's also great differences in terms of agencies, state authorization agencies. Vermont does not have the capacity to really regulate the providers. It simply doesn't have the physical capacity, and other states as well. Are we simply going to alter our regulatory oversight? And maybe the answer is yes. Maybe at the end of the day, sure. If there is nothing better than an individual state reciprocity agreement, if that doesn't work, SARA may be the best alternative. We would be, legislature decides that's the best alternative, then we would certainly carry out its will. What we are saying is we need more information. We need to understand more about what our institutions' needs are outside the state and what other institutions' needs are as they come into the state. We need to have some degree of dialogue about issues like academic priority. We need to have some degree of dialogue about consumer protection. And if we can, and I think we can, sort through those issues, then I think we'll have a reciprocity arrangement that the legislature will find appropriate.
Thank you, sir. The problem is right now that you have 54 separate entities with 54 separate sets of rules and regulations and requirements. For any given state to work out separate requirements with other states puts us back to exactly where we are now. The issue with SARA is to create a uniform set of operating standards. It is our goal with the National Commission, which is what we represented, that if indeed there needs to be some fine-tuning to the SARA agreement over time, and we see that there are additional needs, we will deal with that as it comes up. We are not, I want to be absolutely clear about this, we are not going to negotiate the SARA agreement with individual states. It is the state choice as to whether or not it wants to join SARA. The downside is that your state and your institutions within the state will be at a competitive disadvantage as the agreement grows. Because the costs of individual registration, however you work that out, or individual enforcement, will force an increase in the cost of delivery of services.
Can I just make a quick comment? Because I think Dr. Santiago raises an important point here.
Go ahead.
The example of Vermont, NEVI's role is to help the states sort of survey the options and possibilities here. Then if they make a decision to participate and obtain a legislative or statewide board level approval to do so, that's sort of phase one. Phase two is that they have to actually submit an application to NEVI that's reviewed by a regional steering committee that's composed of individuals from all 6 states and sort of representing all 6 senators. So, for a specific example, to Vermont has enacted or enabled the state to participate, but they've not yet submitted an application. And it's because until they are able to have the staff in place and actually demonstrate that they're going to be able to meet all of the expectations as it relates to reviewing Vermont institutions, as well as responding to the concerns that come from other participating SARA states relative to the participation and activity of Vermont students, then they in fact cannot pursue. So I think to your point, it clarifies sort of the important sort of reality of SARA, and I think it really emphasizes this notion that, you know, it does bring states that in many cases have not necessarily been as sort of full-fledged participants in the consumer protection process up to a new level of standard. Now, is it the highest of standards? Absolutely not. Reciprocity is, you know, fundamentally premised on sort of an acceptable, you know, median point that states can issue, but still very much in that, you know, our estimate is being research. I think it's sort of an important example to illustrate.
It is, and to come back, it is not a closed process. This regional group, as well as the National Council, are going to be constantly reviewing, sharing data, and moving to improve the system as it comes along.
Yeah, and maybe just another thought to that point, you're exactly right. So we will review states every 2 years. Participating states will review their institution annually. And if in any circumstance the institution does sort of, you know, lapse in malfeasance or is unable to sort of keep its commitments, the same is true for states, then they would not be approved with the state program of service. There is sort of an ongoing review process to make sure that people maintain a shared level of application.
Any other questions?
What is it that institutions in Massachusetts can do? You have experience working with other state institutions, what they've done to try to
Well, it has always been my belief that this is going to be institutionally driven. That it's important that your administrators, your administrative leadership make it known to their legislative representation and to their academic representation within the state that they want this. Certainly the ncsara.org site has a great deal of information available to you on how it works, Q&As and facts. It is updated daily as to what state actions are occurring. Sharing that information with others is the best route to this. Sir.
My name is Brian Diga from the Worcester Polytechnic Institute, and I want to support some of the comments that Dr. Allen made earlier, that we smaller universities in particular, no offense to our big brothers down the street, you know, we're just asking for an opportunity to compete, right? And, you know, it's a very competitive landscape in higher education now. It's becoming increasingly difficult for colleges, especially like WPI. We have a relatively high tuition, and it's difficult to provide value for that. We have a lot of challenges without worrying about the burden of the workload and just the inability to attract students from certain states, and, you know, having that extra growth and having those barriers taken down is good for WPI, and I would imagine it's good for all schools, but especially the small schools, because larger schools, we find that the schools that are certified in more states, like 45 out of 50, tend to be larger schools, and that, you know, we can't really do that. So we've got more than 5 that we're not offering. But give us the chance to compete. That's all we really want. Dr. Santiago, I understand your comments about the consumer protection, and I think that just to go back to what the College of Business and Finance was representing, we right now have myriad products and services that are purchased by Massachusetts residents and from other states, and we really don't have. Education is in a lot of ways a product and a service, just like other things that are traded across the and so I just like everyone to consider that maybe the educational product is not that different in terms of those current facts. Not that I'm any expert in state trade, but
Just to go back, remember that SARA is built upon the idea that it is open only to accredited degree-granting institutions. It is built on the triad and on the current federal requirements. It's built on accreditation, it is built on fiscal responsibility, and it has a level application of those principles to all. We started with the basic question of what, and we met with NASASPs, all of the state regulators, and asked the question, what do you really need to know to authorize an institution? And when you stop crossing what we'll call the leakage into the accreditation process and you talk purely about consumer protection, it becomes very narrow. So it is my belief, personally, as an advocate of SARA, and I hope for great SARA, that we do address these questions adequately, that we allow for a great deal of dialogue as we improve this process. SARA ultimately is built on trust. The same trust you would apply if you called another AG in a neighboring state and said, help me out. But it is built on trust. If it does not prove to function at the level that people want, it will be adjusted over time, but you have to start somewhere.
Paul, Michael, so this is how we have to go through the legislature. Through the legislative process, members of the House and Senate can get out and make amendments, whatever bill is put forward. Governor obviously has a say in it, turn the bill with amendments. In other states that this SARA agreement has gone through the legislative process, have any states offered amendments to Dr. Santiago's point that there will be an online registry, that there will be a version back to the state's Department of Higher Ed and Attorney General's Office of Complaints? What would happen if Representative Mark files a bill, moves through the legislative process, and it's different from that was passed in Vermont or Arizona or New Jersey? So how do you reconcile the differences that could occur in the legislative process in all 50 states?
Currently, the expectation is you have a SARA agreement. If a state needs to authorize participation, it's going to authorize participation in the agreement as it stands. If there is an attempt to alter that agreement, at present the state will not play. Period. Reason for that, is really quite simple. If we were to permit that, we end up with 54 different sets of rule and regulation, which is exactly where we are now, so we may as well just take a match to the SARA agreement. SARA is reciprocity and uniformity in that reciprocity. There are, to be candid, there are some discussions in various states about certain processes which they would like to maintain, and the answer has been, you will not be able to participate.
Well, I think it's a really good question because I think the CSG is making the states quite regularly work together to create interstate agreements, and that's really sort of the bread and butter of CSG. So there are literally thousands of interstate agreements and compacts that come from legislatures. And for the most part, the legislative language for participation in SARA is not terribly This was created by sort of a national group that came together to sort of compromise and find a good point that they felt like states could work across. One of the benefits of when a state participates is that they get a greater seat at the table in that national discussion. And this is going to be an agreement that will continue to grow and change over time, insofar as it's working to address needs and challenges and sort of emerging modalities. And I think the reality is, if you look at the SARA agreement, it's primarily about online learning, but we realize that a lot of students are in sort of blended modalities. So there's a lot of change going on, and this is trying to be high enough standard, but also flexible enough to not hamstring every institution that tries to make an innovation in their delivery process. But I think it's important to understand that that's sort of how this has worked, and that's not atypical for how CSG has worked across the U.S. to make states work.
I would be the first to admit, I don't believe that it's perfect. There is no perfection, but it is not akin to taxation without representation. There are numerous stages for input as we fine-tune this process, and indeed, if there are needs that emerge, we will address them. That's what the National Commission is for. That's what these regional commissions are for.
On a related note, as we've researched some of the universities where we might collaborate on their members of SARA, we have seen some of the regulations require that if we want to operate in the state, and if we were a member of SARA, that we actually document that we are operating there and that we are a member of SARA. So I don't know if that's, and I would expect that's part of legislation that was enacted in these individual states. Didn't really change SARA at all, but for institutions that want to operate, they can demonstrate that they are legitimate members of SARA.
So I think the registry idea is a good one. SARA does provide a registry, so insofar as the state had a registry, wanting to participate in SARA, then those institutions coming in through SARA would probably be part of the SARA registry. The state would benefit from both its own registry and SARA.
On those states that have gone through the legislative process, Paul,
Sure.
Okay, thanks. On those states that have gone through the legislative process, are they already engaging in SARA? Do you need all 50 states or 54 states and territories to agree to have SARA actually be implemented? And if Massachusetts decides not to support SARA, does that mean that the institutions within Massachusetts can't, in and of themselves, join SARA? Or do we have to then go through what we're going through right now? 3-part questions.
Yes, and no. If Massachusetts, this is an agreement between states, not between institutions. If Massachusetts chooses not to play, then the institutions within Massachusetts have no place to go. Therefore, you apply state to state. No, you do not. The 19 that are currently there are free to operate amongst those 19 now under the SARA agreement as other states join. The point to be made is that if Massachusetts, as this gains speed, and it certainly is going to, because I look at the numbers and the tables on the site like everybody else, there are a number of states that will say are in process. They're not there yet. They're waiting for a bill. They're doing some other things to adjust their rules and regs. But let's fantasize and say at the end of this fiscal year, there are 25 to 30 states that are participating. The remaining states and territories are going to be in a competitive disadvantage quickly. Institutions are going to start complaining about that quickly as they pay high fees. It should be pointed out that if you have fewer than 2,500 FTE, the institution is going to pay $2,000 a year. That's their fee. If you have between 2,500 and 10,000, or 9,999 FTE, you're going to pay $4,000. And the maximum institutional fee at present for in excess of 10,000 FTE is $6,000. Now, when you look at my annual cost of $325 to maintain, and then you add up what I've put in with $325,000, I would be happy to write that check. And I think that's why ultimately New York has moved in this direction. It should also be pointed out, and I'm not beating on anybody here, but it is the only time I directed the education committees in the state of New York for a number of years. I was with the NEA and lobbied the Northeast. I can go down a whole list, but I can tell you it was the only time in 30 years of experience in that area in memory that all of the sectors came into one room and even said to each other, we don't meet together. SUNY, CUNY, the independents, the for-profits, and all requested this of the regions. So this is a wave that is coming. Either way, online is coming. Better to be ahead of it than behind it. Sir?
Brian Burse here at Pittsburgh State. I just wanted to underscore you hate to turn a student away.
You hate to see a student looking for a particular program and you have to say no to them and they have no other recourse. To me, that's something we all should really keep in mind. We're here for the students. So I think it's really important that whatever we can do to make all of the educational programs we offer available to all of the students who want to partake in them. I think it's really just a good thing to keep in mind for all of us and for the legislators as well.
Hi, to piggyback on that comment on the student piece, as an online learner and as someone that thinks a lot about virtual collaboration with teachers and educators, there's a richness and experience that comes from having students from across the nation, from having teachers in Washington State work with teachers in Massachusetts, try and develop and research solutions around evaluation and compensation systems within public education. So I think from the student perspective as well, this is really beneficial.
Really simple question. What's your sense on California, Texas, and Florida, which represent population-wise many potential students as most of the states are already participating?
You want to know about Florida, Texas, California. California, I'm going to deal with that first. There are discussions going on between WICHE and California. California's biggest problem right now is there is no designated portal agency. The governor cutting. They need a structure. So I think that California will come eventually, but it's going to be a late starter until they solve their political problems within the state. Texas, I think will be a definite yes. There is discussion in Texas. It's going to take a little time, but they're working with us already. It's my understanding that there is progress there. And your other state? Florida, I think will go. Florida will be in the second round. They're already, Florida and Georgia are both in discussion as to how best to deal with this. They have need statutory change. The reason being that a number of these states that put their refund policies and certain other policies within statute and are going to have to go through a session basically to adjust that because there's a uniform. And Dr. Santiago had mentioned clinical placements is concerned. Within SARA, it is not it is when an internship or some of the other internships or some of the forms of student presence have been defined either as clinicals or as state-to-state in interest. There's been no uniformity in that area from state to state. SARA does deal with that, which is something I think that's necessary. SARA does not deal with any form of professional education, licensure issues, including clinicals for licensure. That was a bridge too far for us. We were not going to get into the professions. Anything else? Sir?
I just want to say thank you for the work that's been done on behalf of the compliance officers at other institutions. A couple of years ago, UMass Online started a document that was a huge help to us when starting with the SARA compliance project. Pretty simple question. It seems like this is an ongoing, It seems like this is an ongoing discussion, that there's going to be compromise between the states in the SARA document. The burden on institutions is going to be in the form of cost and staff. So do we have a timeline where we might have an answer from the state of Massachusetts? I know that over the past 2 years, the federal government has pushed back the mandatory date to be in compliance 2 years in a row. That might happen again July 1st, 2015. So I guess my question would be for Dr. Santiago, do we have perhaps a timeline in 2015 where we can expect some sort of decision as to how we're going to proceed with SARA in the city? Thank you.
Determination. It's not ours. We carry out their will. We're prepared to continue conversations, study the matter, learn from experience from other SARA states. I think all that would be helpful in providing the legislature the information they would deem necessary to make a decision on that. That's really not our call.
Could I just make a point? The good news about this is the present system, if you would even elevate it to call it a system, is universally agreed to be broken. And the discussion is, what is the solution to be able to operate? And so I think that's the good news here, is everybody's focused on what is correct. Because when a person wants to learn and an institution wants to teach, it shouldn't be that much of a problem. I just want to close with what I always close with. My advisor, professor, mentor always told me, students are a lot like people.
Anyone else? Well, I want to thank our panel, but I specifically, this is not a we or they type discussion, and I want to applaud Dr. Santiago and the department for their willingness to examine this. We are here to assist in that process. We're going to work together and come up with a rational solution. I want to thank our other panelists and your support. It's been a pleasure to be with you today. And again, we put up various places